Welcome back to the Law News Network, everybody. We're in a lunch break in the Morris Brothers case out of Phoenix, Arizona, and along with us to give some analysis of what's going on in that courtroom is Mike Black. He's a local attorney in Arizona. Mike, welcome to Law News.
Hi, how are you?
I'm well. How are you?
Good.
So what do you make of this case? You have two NBA players facing aggravated assault charges. You have an insinuation that the victim is trying to shake them out for money in a civil case, and that's sort of backing up and causing a clog in this criminal courtroom. What's going on behind the scenes here?
I don't know what's going on behind the scenes, but having tried a bunch of cases, I can tell you that this is going nowhere. First of all, and it seems remarkable, that witnesses are having difficulty identifying who did what because the two Morrises, of course, are identical twins. In addition, this happened at night when it was dark, and from the brief testimony I've listened to, witnesses are having a difficult time identifying people. And then superimposed on all of this is the supposed victim who has sued them for money, who has an obvious interest in the outcome of the case. I think that any rational jury is going to acquit these three folks.
Well, there was an attack that took place. We've got independent witnesses who saw that an attack was indeed occurring. So does that mean everybody goes free just because a couple of people couldn't recognize who was there?
No, there's more to it than that. There are two people who have already pled guilty. Now, I don't know whether they've agreed to cooperate in exchange for a lesser sentence. My instincts tell me no, because the offenses they're all charged with are they're not mandatory prison time. So I don't think that they've agreed to cooperate and testify because they probably have nothing to gain from it.
So where should things go from here then? I mean, we've got this insinuation that the victim is out for money. We've got an insinuation that the police department was both too involved and not involved enough coming out of the defense. So which way is it? Are they myopically focusing on the Morris twins as defendants here and throwing all these resources at it, giving the detective a carte blanche on overtime as the defense has argued last night, and I'm sure into the early stages of the trial today, or is it the opposite, which is the other thing that some of the defense attorneys are arguing, that the police didn't do a good enough job investigating it?
Well, there was nothing to investigate. This was an incident wholly independent of any police involvement. All they had to do was interview the witnesses. My assessment is, because it wasn't that serious, they probably didn't take it and go all the way and interview everybody under the sun, but they interviewed the relevant witnesses. And what your audience has to understand is that, except for the alleged victim in this case, all the other individuals have been interviewed before the trial, just like depositions in a civil case. So the lawyers know what they're going to say. My assessment is, I think the alleged victim was absolutely insane to file the lawsuit unless there's a statute of limitations problem. Absolutely insane to do that because he diminishes his credibility substantially in front of the jury.
Well, it may have been that, but he waited, a year and a half from the time of the attack to actually file the case? How long is he supposed to work? I mean, that's how long he waited. How long is he supposed to wait then? 6 years, 10 years?
I don't know what the statute of limitations is.
So if he waits a year and a half from the time of the attack to actually file the claim, that still damages his credibility?
Oh, you bet. You bet. A jury's going to think that if they haven't already, and there was an intimation that yesterday there was an intimation in some testimonies that he attempted to get another witness to testify falsely, as I understand it. But I think that the victim's testimony is going to be compromised completely by the fact that he's seeking money damages.
Well, I mean, in essence, then every person who's a victim who gets to testify in a criminal courtroom has lousy testimony, in your viewpoint.
No, not at all. Not at all. But if you're a victim and you truly want justice, you don't sue the perpetrator right off the bat.
Off the bat, I mean, he waited a year and a half. Again, I mean, I don't know. I mean, as a journalist, I've covered enough of these cases where while a criminal trial is grinding on, a plaintiff in a civil case files a civil suit against the defendant, either the plaintiff who was actually injured if that person survived an attack, or the family if the victim of the attack had died. I don't see anything strange in this. You do?
Oh, when you say that, I don't find it strange. But as a journalist, you might have covered a lot of these. As a lawyer, I've tried these. I've talked to jurors afterward where similar instances have occurred where victims have sued in assault cases, and they don't like it because it can turn a case around to that simple fact. And if they truly want justice, and they aren't severely injured as this guy wasn't, then they need to wait a tad before they do anything.
I can see at least part of that, but I guess the outstanding question is what the statute of limitations is in Arizona, because that's the piece of it that I don't quite know yet. I know some states have pretty short ones.
Unfortunately, I'm a criminal lawyer, not a civil lawyer, and I honestly don't know what it is. It wasn't on the bar exam, so I didn't study it.
Yeah, well, oftentimes the state-specific statutes of limitations aren't. So, and just to remind folks watching, statute of limitations is the period in which a plaintiff can file a claim in a civil case. If you don't file within that, as the old abbreviation in law school goes, SOL means statute of limitations, and it also means something else. It means you're out of luck. So if you don't file within that window, you lose your claim. Now, I will agree with you, Mike, about one thing. If, based on the level of the injuries here, it's very strange to see a civil claim, especially one where the victim is demanding $7 million at a minimum. This guy had a broken nose.
Yeah, even if he would prevail in a civil case, and your audience has to understand that the standard of proof in prevailing in a civil case is less than a criminal one. But even if he does, unless he's gotten some permanent injury as a result of that, he's not going to get much money. And the fact that he's suing for that amount of money almost makes his testimony unbelievable to begin with, because there's no way, a jury heard that, and there's no way they're going to, a criminal jury is going to think, holy moly, he really did get that. No, he's really looking for something more. And that's going to taint his whole testimony.
I mean, I would say that a guy who gets a broken nose, a weapon with no attack, to use some of the lines that the defense attorneys were using yesterday evening, it would seem to me that that's nowhere near a $7 million civil judgment in favor of this victim plaintiff, assuming he moves forward. We might be looking at medical bills, maybe, 10, 20 grand tops? I don't know. $7 million is astronomical for the sort of injuries that this particular victim suffered.
That's true. For example, I tried one of these cases a couple of years ago where an elderly fellow was hit by my client and fell backwards and was severely injured. He almost died. He was in the hospital for 3 or 4 months and then suffered permanent injuries. We tried it. My client got acquitted, but ended up paying, in the civil case, ended up paying a substantial amount to the victim for those injuries. But those injuries are far more severe than this. And, there's another possibility with the jurors. I don't know what the composition is, but this could be boys are just being boys, and why'd you waste our time? In addition, they're going to get a misdemeanor, a lesser included offense that if the jury thinks they did something wrong, that's the most I think they're going to get convicted of if they get convicted of anything.
I want to take a time out here, Mike, and listen to some of this testimony where one of the witnesses describes this pressure to lie about what he saw. This was really the critical part of this case so far, from my opinion. Let's listen to that, and we'll be back in a couple of minutes.
When you get down there, do you see anyone?
Yes.
All right. Who do you see?
The lady who initially told us that there was a fight going on.
All right. Do you see any vehicles down in that area?
There was a vehicle, which I think was her vehicle, parked on the street, and she was helping him up off the ground, and helping him, and she was bringing him to her car.
Okay. Do you remember if anyone else was with them? those two individuals?
No, I don't remember.
Okay. And it's you, is it you, Jacob Miller, and Joe Murray down in that area?
Correct.
At any point, did you call the police?
No.
Do you know if the police were called?
I don't, at the time, no, but I believe that.
Objection, Your Honor.
Sustained.
And when you see the individual that was getting beat up and the female, what do they do while you're down there?
The individual, what does he do?
Yes.
I don't even know if he was even speaking or anything. I think he was just, he had just gotten beaten up, so she helped him get to the car.
How does he appear to you?
Beat up.
Okay. And when you say beat up, what does that mean?
I couldn't see his face close up. I mean, by the time we had gotten out there, she was already helping him up into his car, so I didn't really get to see what he looked like.
All right. Did you help him into the car?
No.
Do you know if Jacob Miller helped him in?
I don't think Jacob did.
Okay. And do you know if Joe Murray helped him into the car?
I don't remember.
Okay. At that point, what happens?
At that point, they get into their car. I believe she had taken him to the hospital, and me, Joe, and Jacob walked back to the parking lot, and I got my kids back on the van, and we left the arch.
All right. And you've been interviewed a couple times after this by the police department. Is that correct?
Yes.
All right. And you were also contacted by an individual named Alonzo Hickerson. Is that correct?
Correct.
When were you contacted by Alonzo Hickerson?
I don't know the exact day, shortly after the incident occurred.
Okay. And what was the nature of that? Was it by phone?
Yes.
What was the nature of that conversation?
The initial conversation, reason he was calling me had to do with basketball. I don't remember what exactly about basketball. We're both coaches, we coach at a prep school, so we talk about basketball topics all the time.
Was there any discussion about this incident?
Yes.
What was that discussion about?
It initially started with him asking me if I had heard what happened.
Okay.
I responded telling him I had heard what happened. At some point in the conversation, he had said something along the lines of, I don't know the exact words or verbiage that was used, but he had made a comment about what I saw, and he asked me if I had seen the Morris brothers beat up the gentleman that got beat up.
Okay.
I initially, go ahead.
Go ahead.
Initially responded saying no. And then he continued and said something along the lines of, well, if you give a statement saying that you've seen or saw the Morris brothers get beat up, the gentleman get beat up by the Morris brothers, the gentleman getting beat up is going to receive a settlement, and you will receive some kind of compensation / money, something like that.
Okay, so what did that mean to you? What did you believe that he was trying to encourage you to do?
Give a false statement.
All right, and had you already talked to police by the time he made that call?
I don't recall. I believe it was before I talked to detectives, but I don't remember if it was before or after.
Okay, and in response to that, did you indicate to him anything about that?
Never. I initially shot down the idea. I told the gentleman, Alonzo, I have no interest in giving a false statement. I tried to laugh it off, honestly, because I was shocked that somebody would ask me to do something like that. So I tried to kind of play it off. When you're in a conversation and someone brings up some kind of crazy idea, I try to quickly change the subject and veer away from the situation and told him I wasn't interested.
Okay. So did that influence any of your statements to police?
Nope.
Did that influence any of your statements here in court today?
No.
So right there, one of the most critical pieces of testimony so far in the Morris brothers case that might flip the entire case around. Mike, we've got this accusation on the table that this witness was asked to lie about what he saw, that if he implicated these NBA players, these twins, then any payout from the NBA players to the victim would then result in a kickback to the witness. Now we're talking about witness tampering here.
Oh, and if a lawyer did it, it's completely unethical. This, in my opinion, coupled with the lawsuit itself, is enough to just throw the case. I saw the beginning of this fellow's testimony. I didn't hear the testimony on TV, but I saw him testify, and he was a very, very credible witness. The portion I saw was he was there with some audio-visual equipment, and he was using that, and he was going to tape the tournament games and then sell them back to the teams. And he was an extremely credible witness. And if that was the offer made to him, their ship is sunk.
Yeah, those are pretty strong words from you, enough to, quote, destroy the case. The ship is sunk. I don't remember it being put any more pointedly by many other people here.
Well, they don't. The Morrises don't even have to testify in this case. I mean, with that testimony and the questionable issue concerning who hit who, I don't think the prosecution has a chance to win this case. Now, you know very well that in these preliminary negotiations, the Morrises and the other fellow had to have been tendered a plea offer that they turned down. So I don't know what it was, but you know that they wanted him to plead guilty. And based on this testimony, I wouldn't have pled guilty to this in any shape, way, or form.
Yeah, I mean, I think that the lawyering across the board here has been quite good overall. I think the prosecutor is doing as good of a job as possible, and the defense lawyers have been right on point here. Do you have any experience with the people who are litigating the case?
Yeah, I know two of them, and I haven't ever tried any cases with them. I don't know the prosecutor, but I will say I was a prosecutor in Florida, in Fort Lauderdale, before I moved here and became a defense attorney, so I've done both. And I can tell you that from a prosecutor's perspective, this is not a very good case. And he's probably doing the best that he can. And you have to understand that in Arizona, unlike other states in federal court, we have an opportunity to interview all the witnesses. So, but for the victim in this case, the alleged victim, the defense attorneys knew what the testimony, and had a pretty good idea what the testimony is going to be, and in fact could use those questions from the previous interviews to cross-examine them and perhaps impeach them.
I also thought that the judge was very much on the ball in this case. Have you litigated cases with her?
I laugh because I spent a month in court in front of her. She's very good, very smart, runs a tight ship, and won't let anybody get away with any monkey business, I'll tell you that.
Well, that's the reaction that I've also established for myself here. When there's an objection, she's right on top of it. She knows the issue based on her demeanor and her poise better than the attorneys do, and she makes a correct ruling probably faster than any judge that I've seen in any of the case that we've covered here. So
yeah, she's really good, and it's really kind of interesting because before she got on the bench, she had no criminal law experience at all. She was primarily a civil lawyer, and so I got to know her pretty well because I literally was in trial with her for 4 weeks during, and I was really impressed with her.
Yeah, I think that she's trying to handle the case about as well as she can. You know, one thing that we also did find out in this case, and I want to play this clip next, is apparently some of these accusations that there may be, kickback payments didn't come to the attention of the police until the last couple of weeks. And this case has been going on for quite a while. So I want to listen to how the lead detective, Fred Santos, handled that on the witness stand.
Of course, you didn't learn until last week that Mr. Hickerson was attempting to suborn perjury in this matter, right?
Objection calls for a legal conclusion from the witness.
Sustained. Rephrase, please.
That Mr. Hickerson had offered at least 2 witnesses some financial payment in exchange for testimony implicating Marcus Morris and Markeith Morris.
I would object as to facts not in evidence. I believe one of those two witnesses indicated was his interpretation that referenced financial motivation.
Sustained. Could you rephrase?
That with respect to two witnesses, for both of them, Mr. Hickerson had told them or suggested that, rather asked them to provide testimony implicating Marcus Morris and Markeith Morris, right?
I recall that, hearing that.
That he wanted them to say that they had seen Marcus and Markeith physically assaulting Eric Hood, correct?
Judge, I would object. He's offering prior consistent statements.
Sustained.
And that with respect to at least one of those individuals, there would be a financial payment to that individual were he to do that, correct?
Same objection from the state judge.
Overruled. You may answer that question.
I recall hearing that information.
You weren't part of the state's efforts to locate Mr. Hickerson for this trial, were you?
I wasn't what?
Part of the state's efforts to locate Mr. Hickerson to bring him here for this trial.
No.
You know some effort was made in that regard?
No, I wasn't aware of that.
You weren't?
No.
You weren't aware that the state attempted to reach Mr. Hickerson, but he somehow didn't respond to any of their efforts?
I really don't recall anyone telling me we're looking for Mr. Hickerson.
You had communications over the course of your investigation with, I think, three different attorneys who told you they were representing Eric Hood. Is that right?
Yes.
Christopher Williams, Eric Bowman, and David Rubin.
The first one, I don't remember. Williams?
Kit or Christopher Williams.
That name doesn't sound familiar to me, but David Rubin, and I spoke to David Rubin, but Bowman, I don't know if I ever had any conversations with him.
You told me when we spoke some weeks ago, it was unusual in your experience to have the amount of contact with a victim's lawyer such as you did in this investigation.
Or me to have contact?
Yes. The amount of contact that you did in this investigation.
It's, I believe it's unusual.
And you told me you had a number of conversations with Mr. Rubin in particular, is that right?
Yes.
And you had asked him really for any information that would be helpful for the investigation, right?
That I asked him?
Yes. If he could identify witnesses or provide medical records or provide you with any information that would help further the investigation, correct?
I already had most of the information that I needed.
Okay, folks, so that's some of the testimony that's raising so many eyebrows here and causing head scratching, all sorts of other concerns here. So, Mike, you've got cross-examination of a detective who apparently just learned within the last couple of weeks that there are accusations of witness tampering out there, saying witnesses would be paid a kickback in return for testifying against these NBA players. And did cross-examination, or rather did cross-examine that detective to say, hey, look, that's a felony, right? And of course it is.
Yeah, with regard to investigating that particular thing, this detective might not be on the same squad that's responsible for that. It might be assigned to somebody else. But whoever did that, whether it was the so-called victim or some intermediary he got to do that, somebody's in a load of trouble because even if he denies it, it's going to be attributed to him anyway.
Yeah, it's not a good thing in the slightest, and I'm starting to agree with you. I think that it's going to cause some pretty serious problems for the prosecution here.
Oh, that's a death knell for this case. It's kind of, I wonder when it came up, because the witness who testified that he got contacted was probably interviewed some time ago, meaning that the offer hadn't been made yet. My assessment is that the defense just found out about it recently, and my assessment is that the witness then got re-interviewed about it, and everybody knew that this was going to come up. But I don't recall anyone mentioning this in their opening statement. If I knew that had happened, I certainly would have laid it out. So the possibility is that it just popped up right before the trial.
You know, I would have to agree with that. I don't recall hearing a lot of this opening in the opening statements either. So is it possible that this is something that has come out literally in the middle of this case?
Yeah, it certainly is, because that is a fact that every defense attorney in the world would be licking their lips to get to use. And my assessment is it just popped up recently, and if the defendant's responsible, it shows he's a complete idiot to do something like that. Now, the possibility exists that someone did it completely out of the blue, but if you believe that, I've got some land here in Arizona to sell you.
Yeah, you know, I'm like I said, I'm starting to agree that this case has got some pretty serious issues. At first blush, it sounded like it was colorable, and then we had these other couple of witnesses saying, "Oh yeah, we were joking about, you know, getting a big payday because these two guys beat this guy up." And then I'm like, "Okay, well, you know, the joke isn't that good of a joke. It's not funny. It could have some serious repercussions." But I was inclined to believe the friend of the victim in saying, "Oh yeah, it was just sort of a joke, and probably shouldn't have said it, but we said it. Oh well, it's just the way we were reacting to a stressful situation." I was almost willing to write it off, but then when that came out last night, and a little bit more this morning, I started to say, you know, I'm not sure that this case is going to go any further than an acquittal.
No, I'll be shocked if it's anything. But if you remove those two instances, the lawsuit and the claim to give the witness money, assuming it came from someone on the defense side, if you remove those two and just looked at the case, it might be an even up assault case without that. But that is so devastating to the credibility of the witnesses that I don't see how this case can survive. I'll bet that jury's back in 30 minutes with a not guilty.
Well, I'll be certainly curious to see whether that prediction holds water. Mike, is there anything else in this case that we're missing that has jumped out in your attention?
No, well, just those two things. The lawsuit. I mean, I would die to have those two facts in any case. But I just think the last one, the most recent one, with regard to offering the witness money to change his testimony, is so recent and so devastating that this thing, I wish I could frame that and have it for all my trials. That's going to be the death knell of this case.
Yeah, you know, I'm starting to agree. So, Mike Black, a local attorney in the Phoenix, Arizona area, we appreciate your insight here on the Law News Network.
Thanks. It's been fun.
Okay, good to see you.